morning, everyone, and welcome back to another episode of SEC Roundup. I'm Nick Morgan, the co-founder of ICANN, Investor Choice Advocates Network, and one of the co-hosts of today's episode. I'd like to welcome, as always, my partner in crime, Tom Zaccaro. Tom, thanks for doing this.
Thank you, Nick.
And our special guest today is Professor Hal Scott from Harvard Law School, who, among many other things, is also the director of the Committee on Capital Markets Regulation, a bipartisan nonprofit organization dedicated to enhancing the competitiveness of U.S. capital markets and ensuring the stability of the U.S. financial system. That's a mouthful, Professor. Thank you for coming on this morning.
Thanks for having me.
The reason we're getting together is a couple of proposals. Well, one's a proposal, one's a statement by the SEC and its staff that affect publicly traded companies. There are really two issues we're hoping to get Professor Scott's insights on. The first, I'll just mention briefly, is a decision by the Division of Corporation Finance to apparently not use a company's decision to exclude arbitration provisions. We'll get into the details of this as a means of preventing registration statements from going forward. I may have misstated that, but Professor Scott will correct me when we get to it. And the second topic, Tom, I'm hoping you'll give a little context for, as everyone who listens to this podcast knows, most public companies are required to file annual reports on Form 10-K and quarterly reports on Form 10-Q. So there has been a proposal floated, although not yet put into the form of a rule on that topic. Tom, can you give us a little context on that quarterly reporting issue?
Yeah, sure. Happy to do so, Nick. So the issue really gets down to the frequency with which public companies will report their financial results. For the last 50 years or so, companies have reported quarterly, and the proposal, which is picking up steam, is that the quarterly reporting requirement be changed to semi-annual, so every 6 months rather than every 3 months. Chairman Atkins of the SEC has been a proponent of this, as has President Trump, and recently President Trump tweeted on his social media accounts that the SEC should switch to semi-annual reporting. The idea here is, I think, not only to reduce the costs of financial reporting for public companies, but also to prevent what is termed short-termism, where investors are focusing on quarterly results, and a blip in a quarter might affect investor confidence in a company, which might otherwise smooth itself out over the course of 6 months. We are used to quarterly reporting, so it seems like a big change, but many other countries, including countries in the EU, for the last decade or so, have switched to semi-annual reporting without any major financial calamities. And of course, companies are always, even if we were to switch to a 6-month reporting, companies are free to report on a more frequent basis if they so choose. So with that, let's hand it over to the expert.
Yeah, let me pick up on that last point, Tom, and Professor Scott asked, because you made that point that Tom just picked up on, which is the proposals, and again, they're not in rule form yet, are to allow greater flexibility. It wouldn't mandate semi-annual reporting. It would allow for semi-annual reporting. And you made a comment in an article I saw, Professor Scott, about how that potential for greater flexibility might be received by investors and public companies. What are your thoughts on this proposed change?
Yeah, I think it's very important to make the point you just both made, that this is saying the only requirement is semi-annual, but you're free to go do what you've been doing all along and do quarterly. So let me first kind of talk about the short-termism justification, or avoiding short-termism justification for this. I'm not sure, how much going from quarter to semi-annual is going to change that. I don't think it'll change it a lot. I'm not sure that just because you're getting quarterly reports, you're going to be a short-termer. We've got, the market has changed a lot during the period of time in which we've had quarterly reports, where we have indexes that own, maybe 25% or so of the market. They're going to keep holding that. They are long-termers. The very product is a long-term product. So I don't see this having much impact on that. Maybe 25 years ago, before the index funds came about, it would have had more impact, but I don't think that's the major justification. I think the major justification is the cost. And I think I can't imagine that any, major companies are going to move from semi-annual to quarterly. First of all, they've got the programming. They've done this forever. Actually, it might be more costly to switch at this point than it is to continue to do what they're doing. And I think more importantly, the asset managers will be very upset if these companies start moving towards semi-annual as opposed to quarterly. So they're going to be weighing in as shareholders to these companies not to make changes. I think where you're going to see a potential change is in smaller companies that don't have an established method of or timing on their reports, where doing it on a quarterly basis as opposed to semi-annual now from the start would be much more expensive for them, where the shareholders aren't as concerned with getting these constant updates because they understand that this company is going to get started as a public company. So I think that's where you'll see the adoption of this, not for established public companies.
So it seems like it's entirely feasible that we end up with a marketplace that has some companies reporting on a semi-annual basis for whatever reason, and others that choose to continue with quarterly reporting, both of which would be permitted under the idea that's been floated.
Totally agree. Yeah.
And of course, it's early days on this. There's not even a proposed rule for any of us to look at and comment on, but presumably, given the momentum the idea has, we will see a proposed rule come out.
Yeah. I mean, as Chairman Atkins said, this is to create more flexibility, not one size fits all. And I think that purpose is a good purpose. And so nobody's forcing anybody to do anything here. It's just giving people options.
Right. Well, let's pivot to the other issue, which has taken effect because it doesn't need a rulemaking by the SEC, and that is whether registration statements will be allowed to go effective if they include a mandatory arbitration provision. You've thought about this issue and commented on it, Professor Scott. Can you give us your thoughts on that change?
Yeah, I've been involved in this issue for a very long time. When the Committee on Capital Markets Regulation was formed in 2006, at the behest of the new Secretary of Treasury, Henry Paulson, he asked us to do a report on why our public market was losing the attractiveness to foreign companies coming here and listing and trading. This was due period of London light touch. Okay. And so you saw a number of foreign companies that you might have expected to go public in the U.S. market, not doing so, going to London instead. Today, the threat to the public market is, I wouldn't say primarily that. It's more private companies deciding not to go public. But the fact of the matter is that we have had a constant contraction of the public market, okay, in terms of number of companies and total market capitalization over time. And that's a problem. Okay, so when Paulson became Secretary of Treasury, he asked the committee to do a report. This was like post-Sarbanes-Oxley, 2006. So, when I started with this, I said, well, it's going to be, regulation Sarbanes-Oxley, the major issue. No, that wasn't the major issue. The major issue was liability, okay, that foreign companies didn't want to come in here and be subject to securities class actions, okay, which they felt were a total burden, okay, and unjustified. And no other country at that time had anything like this. Now, both Canada and China have some version of it, but nowhere near as open-ended as we have. So we identified that as the major problem, okay, in our market. And at that time, Paul Atkins was a committee on the SEC as a committee member, okay? And Paul and I kind of went on the road kind of talking about this and got all sorts of, pushback and so forth about like we're undermining investor protection and this, that, and the other thing. Well, the fact of the matter is, I know this is a little long-winded, but I think it really gives the background of why this proposal is important, is that if you look at the securities class action, you got shareholders suing themselves. And again, with the rise of index funds, this is being even more careful. I mean, so, the class includes the index fund, and yeah, they're the shareholders of the company. So they're suing themselves, right? And the lawyers are making 25% on the turn. Then people say, well, it's to deter bad behavior. Well, when you really look into it, it doesn't deter bad behavior, because if you look at how kind of bad things come up, discovered, it's not by some plaintiff's class action lawyer filing a suit. He only files it after somebody else has discovered it. Okay, like the SEC or the press or somebody, or insider who has gone and told everybody about it. So and it's very costly to deal with this, because they're all settled. Nobody litigates this,
Right.
because you're talking billions of potential liability. And the lawyers know that. They're in it for the settlement. They're in it for the money they're going to get on the settlement. If you look at retail investors, and maybe each of you have had this experience, I know I have, when they get a notice of this thing, I put it in the wastebasket, because the time it would take me to fill out all the forms is less than any money I'm going to get as a result, right? So if you look at who actually comes forward from small investors to collect this money, it's a very small number. And so the money really goes to these, big shareholders suing themselves.
Right.
The whole thing makes no sense. Okay, so that's the background. All right, so for years, I and the others have tried to kind of get the SEC to back off of what is, I think, many perceive as their position, to say that they're in favor of this, although they really never articulated it. I think it was widely assumed that if anybody tried to get out of this, it would be a problem. But over the years, there was a big legal issue, whether if you adopted arbitration, individual arbitration, as a method to substitute or grievance against the company in lieu of a securities class action, that would violate federal securities laws. The Supreme Court has made it clear in a number of cases that's not the case. The only legal issue that remains is whether under some state law, okay, like Delaware in particular, such a provision would violate state law. But even if it did, there's the fact that there's a Federal Arbitration Act. This is what motivated the Supreme Court to say it's okay. In 1925, the Congress adopted something called the Federal Arbitration Act. And the Supreme Court has said, look, the securities law say you have to have a way to, write a grievance, but they don't specify how. And so here's the Congress that says it's okay to do this by arbitration, generally, to solve disputes. So if a state were, and some argue recent amendments in Delaware have this effect, to try to prevent arbitration, it could be preempted, okay, by federal law, because federal law would say states can't do things that's in conflict with the Federal Arbitration Act, 1925. Okay. All right, so that's the background. I think in 2010, I might have the year wrong, it might be 11, Carlisle, in going public, and this is against the background of a lot of writing I did about the report of the committee and so forth, put an arbitration provision in their proposed registration statement to the SEC. And the SEC refused to accelerate, which is critical, their registration statement. People want to go public as soon as they want to go public. Right. Otherwise, they have big risk. And so Carlisle, because of that, took it out. And ever since then, it's kind of been assumed that the SEC is against this process, doing arbitration. That, therefore, when the SEC came forward recently with this new statement, basically saying, no, we were wrong in Carlisle, we're not doing that any longer. We are not going to hold up a registration statement, okay, due to the fact somebody's put an arbitration clause. Now, they didn't tackle the preemption thing. They observed that Delaware law might prevent this, but they didn't get into sort of whether there would be preemption. Recognize there are other states than Delaware. You've got the new Texas Stock Exchange. trying to sort of capitalize on overreach by Delaware regulation. I wouldn't be surprised if Texas made it very clear that this was not a violation of any Texas law. So at that point, anyone who went public and listed on the Texas Stock Exchange would be clearly legal. Okay. Now, the wider implications of this, Nick, is not just for companies going public, it's for existing public companies deciding to substitute arbitration for securities class actions. And this is what we looked at in 2006. We weren't just focused on IPOs. We were focused on all public companies potentially using this. And although the SEC did not say anything about it, the clear implication of their position is if it's legal to do it in an IPO, why wouldn't it be legal to do it otherwise?
Right.
And that could be done either through shareholder action, okay, a proposition get voted, or the management, okay, it could itself amend the bylaws. Again, maybe some states would object to that. It's probably clear this would be legal federally for the same reason it is in the IPO context. So this statement that they made, I don't think people have fully understood
Yeah.
the bigger implications of what's going on here.
Yeah. Yeah. Well, I hadn't thought about the point you just made that it might go beyond registration statements to existing publicly traded company. That's interesting. I guess we'll wait to see if an existing public company tries to take advantage of the
Well, that I think the way this is going to evolve
Yeah.
is it's first going to be done in the IPO context.
Yeah.
Okay. And that'll get the ball rolling. Okay. And I think as soon as it's like clear the SEC's okay with that, you're going to see some public companies, maybe again in Texas, okay, who are already listed or not going through IPOs, changed. And that'll further get the ball rolling. My view is once it gets rolling, you're going to see huge roll. Okay.
Yeah.
The first mover problem is there.
Right.
But once it gets going, I think it will kind of snowball.
Right. And we shouldn't underestimate the plaintiff's bar. So maybe.
Oh, no. In the plaintiff's bar, another sort of very interesting, but the plaintiff's bar doesn't tend to line up with the, conservative Republicans. They seem to be in the other party mainly. So in the politics in Texas, it isn't going to be that, the plaintiff's bar is going to step in the way of this. So other states obviously could be very different. Okay. But then you'll see state competition over this issue, as we have in many other areas. Anyway, yeah. So we just have to see what happens. I think it'll be a gradual process.
Yeah. Yeah. Well, we'll keep our eyes out. Tom, it looks like you have a comment.
Yeah, I do, Professor. I'd like to just ask a question from someone who defends class actions and does arbitrations. Will arbitrations be a panacea for companies who are afraid of entering our markets? I can see the other argument that federal judges are at this point very well versed in federal securities law and the PSLRA, and these cases get dismissed clearly with a higher frequency than other civil cases. And, do we want to leave this in the hands of arbitrators who are going to be selected by the parties and may not be as well versed in federal securities laws, and companies are going to find themselves stuck in arbitrations with arbitrators who may not be as well versed as federal judges in getting rid of cases that lack merit?
Well, I think it depends on the arbitrators, and I think you would want to select very sophisticated arbitrators.
Yeah, of course.
Another thing to be conscious of in this context is if you look in the consumer area, which is totally different because this is consumers are not suing themselves. That's a total, and I'm not advocating the adoption of this for consumer litigation, but a number of companies have in that context adopted arbitration. But the lawyers, clever as they may be, have kind of imported mass arbitration. So what they do is they solicit all sorts of people to sign up for arbitration, right? And then they bring mass arbitration, which turns out to be probably even more burdensome than a class action because of the arbitrating fees, the process itself, and so on. So whoever goes down this route on arbitration should go down the route of individual arbitration, and in their arbitration agreements have to make clear, and I think there are ways to do this, we don't really have time to go into it here, to prevent mass arbitration. But this is a danger, okay, going down. I think it's more of a danger than kind of getting the law wrong. From the point of view of the company, this is a very big issue, okay?
Yeah.
So they have to adopt an arbitration provision that lawyers can't kind of convert into mass arbitration.
Yeah, good point.
Wow. So I think the key is we will have to watch for the first company that tries to do this. In other words, this being have an IPO.
Could be Tesla. I mean,
Tesla, right? Or we'll see.
I mean, Elon Musk is no friend of securities class actions.
Right. Well, when it happens, maybe we'll check back in with you, Professor Scott. But for now, maybe we'll leave it there. And thank you so much for providing your insights on these issues. Tom, thank you as always for co-hosting. For everyone else, if you want information about ICANN, you can go to icanlaw.org. And we'll see you all on the next SEC Roundup. Thanks very much.
Enjoyed it. Thank you.
Thanks.